Company law, unit 2. So let's start with the first concept of company law, unit 2. Procedure for incorporation, or section 3, formation of the company. It has been asked for 10 marks. Procedure for incorporation. So, or section 3, formation of company. So what is the procedure for incorporating a company? A company may be formed for any lawful purpose by the following. So a company can be formed for a lawful purpose only by the following methods. First, a public company. For a public company, we need 7 or more members. So 7 or more members can come together and create a public company. Then for a private company, we need 2 or more members. So 2 or more members below 7 can come together and create a private company. Then 1-person company, a private company with 1 member only. So only a 1 member can come and create a 1-person company. So this is the formation of company, section 3. Next, these people have come together. Say for example, now 7 or more people have come together and they want to create a public company. The next is they should take a subscription. So they have to subscribe their names to memorandum of the company. So these people, they will have to subscribe their name to the memorandum of the company. The memorandum of 1-person company has to indicate the name of 1 more person. In case the main person dies, the other person's consent has to be recorded with a registrar. So in the memorandum of the company of a public and private company, we have all the name of the members of a public company and a private company. But since in 1-person company we have only 1 person, so he has to name another person as a nominee. So in case if the main person dies, the other person can take care of the company, so that the company exists. So this is the subscription. The next is kind. They will have to specify the kind of the company. The company formed under this section may be a company limited by shares or guarantee or an unlimited company. So they have to specify the limitation of the company, the kind of the company, whether the company is limited by shares, whether the company is limited by guarantee, or it is an unlimited company. They will have to specify. The next is they have registration. They have to register their company. So registration of a company is obtained by filing an application with the registrar of companies. So they have to file an application with the registrar of the companies. So section 7 clause 1 of the 2013 Act says that application should be accompanied with the following documents. So what are the documents to register a company? So along with this document, they will have to file an application to the registrar of the companies. So what are these documents? First is a memorandum of association. They need to have a memorandum of association attached. Then an articles of association. Then a copy of agreement. If a company proposes to appoint managing or whole-time director or a manager, so before the starting of the company itself, if the company has appointed a manager or a director, then a copy of agreement with that manager or director they will have to attach while filing with the registrar. The next is a declaration that all requirements of Act have been complied with. So a declaration by all the members. So for a company, for an incorporation, we need first whether it is a public company, private company, or 1-person company. So that many members they need. For a public 7, private 2, and a 1-person 1 member only. Then they have to subscribe their name to the memorandum of association. Then they have to specify the kind of the company, whether it is limited by shares, guarantee, or an unlimited company. Then they have to file an application with the registrar of the company for registration. So they need 4 documents for the registration: a memorandum of association, an articles of association, a copy of agreement with the director if they have appointed, then a declaration. So this is how they form a company. Case law, Selvarajan versus Registrar of Companies. So documents of registration have to be printed out and not Xerox. So yeah, whatever the documents they create for a registration, they have to take a printout of that and not Xerox. Certificate of incorporation. So after incorporation, members become a body corporate capable of performing all functions of incorporated company. Certificate is a conclusive evidence. So after incorporation, they became a body corporate and they can perform all the functions of a company, and they are provided with a certificate that they have been incorporated, and the certificate is their conclusive evidence. So from section 3 to section 7 you have to write, even if a certificate of incorporation has been asked for 10 marks sometimes. So you have to write from here to here. So next question. Memorandum of Association. So Memorandum of Association has been asked for 10 marks. So what is a Memorandum of Association? Section 2 clause 56 states its meaning, that a memorandum of association of a company as originally framed or altered from time to time in pursuance of any previous or present company law. So this is the definition in the section. So what is a memorandum of association? Memorandum of association is a document that we need while applying with the registrar. So since it's a document that we are using for registration, it should have some contents. So what are its contents? If we look at that, we will understand memorandum of association. So fundamental clauses of a memorandum of association. So what are its contents? First, it contains a name clause according to section 4. So it must have a name to establish its identity. So a company should have a name. So in a memorandum of association, first a company should specify its name. So what are undesirable names? So the company name should not be identical with any other company. Say for example, if we have one company and we cannot name our company as the same as that previous company, so the name should not be identical. Then too nearly resembles. The company name should not too nearly resemble to the other company name, so that it sounds as that company name only. So there should be no too nearly resemblance. Next, registered office clause, section 12. So in the memorandum of association, the next content is a registered office clause. So within 30 days of incorporation, decide and give notice to a registrar. So within 30 days of incorporation, the company has to decide where its registered office will be, and the location they have to give notice to the registrar. So the memorandum of association contains a registered office clause. The next is object clause. So this is important. In the memorandum of association, the company has to specify their object clearly. So what is this company's purpose? What are they manufacturing, or what are they going to do? They have to specify it clearly in the memorandum of association. So, and the company cannot do ultra virus of object. So this is an important question separately asked for 10 marks. We will discuss it later. Here I will tell in brief. So not to ultra virus of object. So if a company specifies its object in a memorandum of association, so it says that it will manufacture pens. Later, after incorporating, they can only manufacture pen. They cannot sell pen now. If they try to sell pen, it will be ultra virus. So in the memorandum of association only, they will have to specify that they will manufacture, sell, make, etc. Everything they specify, only that much they can do. So this is the object clause. The next is a liability clause. So liability of members shall be limited by shares. Example. So they have to specify the liability of the company, whether it is limited by guarantee, limited by shares, or an unlimited liability company. They will have to mention a liability clause in memorandum of association. The next is capital clause. So the total capital, number and value of shares and divisions they will have to mention. So what is the total capital of the company and how many shares they have divided into? They have to mention it in memorandum of association. Case law. Ashbury Railway Carriage and Co. versus Riche. So objects of the company were make, sell, lend on hire railway carriages. So these are the objects of the company: to make, to sell, and to lend on hire railway carriages. But what they did was, they tried to finance a construction of a railway line, and by contracting with this person Riche. So they tried to finance a company, held that it was ultra virus of their object. Since they have not specified in their object, it was ultra virus of their object. So this was a memorandum of association. So mainly it contains clauses, as we saw. Name clause, registered office clause, object clause, liability clause, and capital clause. They have to mention all of these and put it into a memorandum of association and apply to a registrar for registration of the company. So the next important concept is doctrine of ultra-vires. So what is this doctrine of ultra-vires? We saw in memorandum of association in the object clause that the company should not act ultra-vires of its object. So that itself is the doctrine of ultra-vires. Doctrine. Ultra means beyond, virus means powers. So beyond its powers it cannot act. An action beyond the objects of a memorandum of association is ultra-vires. So any action a company makes beyond the objects or beyond the memorandum of association, then it will be called as ultra-vires. So what are the consequences of ultra-vires? So what are the consequences if the company goes ultra-vires of its objects? First, injunction. So restraining from proceedings. So the company will be restrained from proceeding further with that act. So injunction first. The next is personal liability of the directors. So it is the duties of the promoter to see that the company does not go ultra-vires of its objects. So the promoters will be personally held liable to replace it. The next is breach of warranty of authority. So the promoters are personally liable to third party for breach of warranty. Ultra-vires acquired property. Say if they are doing an ultra-vires act and by doing that act they have purchased certain property. So even though the purchased property was acquired through an ultra-vires act, the right over that property is secured. So it is a power to a company, even though obtained ultra-vires. So even though through an ultra-vires act a company purchases a property, the right over that property is secured. The property is the company's only. The next is ultra-vires contracts. So if a company makes any ultra-vires contracts, then the contract will be void and has no legal effect. Ultra-vires torts. So we saw that the contracts are void and no legal effect, but still the other party has suffered loss. So can he sue for tort? The question arises. So the company is only liable if the activity that is ultra-vires activity that is done is within the scope of a memorandum. So it should not be ultra-vires. It should be within the scope of a memorandum only, and the servant committed tort within course of his employment. Only then the company's members will be personally held liable. So even torts cannot be done because it has to be within the scope of memorandum. So these were the ultra-vires acts. So we saw that the ultra-vires act means the act which is done beyond the scope of memorandum of association, and for that we have certain consequences. Case law, Ashbury Railway Carriage & Co. versus Riche. We saw that case, it is the same case. Their object was to make, sell, lend and hire railway carriages, but they tried to finance a construction and it was held as ultra-vires of their object. The next topic is Articles of Association. It has been asked for short notes, 6 marks. So what is Articles of Association? Meaning. So AOA as originally framed or altered from time to time or applied in pursuance of any previous company law or of this act. So what are this article of association? Means it is also a document while applying while registering a company along with a memorandum of association. They will have to also attach a article of association. So what is the difference? So memorandum of association is like a constitution of the company. So it's like a constitution, and the article of association is like a bylaws. If we compare to our Indian law, we have first a constitution. We have constitution as the main law. Then in that we have other different laws like IPC, CRPC, etc., which is bylaws. So memorandum of association is the main constitution of the company, while article of association is like bylaws. So content. So it is the bylaws and internal regulations of the company. So article of association specifies the bylaws and internal regulations of the company. How a company should perform, what are the laws, when a person should arrive, when a person should leave, at what time the company will operate. Everything will article of association will contain. So in the Companies Act, is the 2013 Act, in the Schedule 1, they have given this preset model forms tabular forms F, G, H, I and J, where they have specified different rules for different company. They are preset rules. So if a company wants, if a public company, then they will have to take in this rules only. So if F is applicable to companies limited by shares. So companies which are limited by share, they will have to take this EF tabular form and follow that rules, that article of association. Provision for entrenchment. So article of association is like a bylaws. So entrenchment means amendment. Can we amend the laws later? If they want to change the law, can they do it? So for changing a law, there are certain conditions that they should comply with. The first is only if more restrictive than previous. So if the article of association, the new law they are going to make, it should be more restrictive than the previous one. It should not be more loose, more restrictive. Then the private company, for a private company, the consent of all members they should take. If it's a private company, then consent of all members if they take, then they can amend. For a public company, they will have to do it through a special resolution only. They have to pass a special resolution and then they can amend the article of association. And the amendment should not be ultra vires of the memorandum of association. So it should comply all the rules of a memorandum of association. It should not go ultra vires. Case law. Hutton vs. Scarborough Cliff Hotel Co. Limited. Facts. A special resolution issue new shares. What the special resolution said was issue new shares with a preferential dividend. So they passed a special resolution which stated that issue new shares with preferential dividend. But this was ultra vires of the memorandum of association. So this particular was not contained in the memorandum of association. So it was held that it was inoperative as ultra vires of a memorandum of association.